We usually would have a free preliminary chat with you to obtain some information regarding the case and to assess essentially whether we feel that your case may have more of a chance of winning than losing. If so, then we would be able to take your case on a no-win, no-fee basis. We would then obtain all of your medical records and conduct a thorough review to determine whether or not you may be able to satisfy the legal test for negligence, which of course is extremely stringent. Ultimately, we are dependent on the opinion of independent medical experts to assess whether you can satisfy that legal test. The legal test forms two parts. First part essentially is that your doctor has breached their duty of care towards you in that the treatment fell below a reasonable standard as judged by a responsible body of medical practitioners in that particular field. So it's not sufficient to say that they could have done better or that they can be criticised. If they acted in accordance with a practice that was accepted by a responsible body of doctors in that particular field at the time, then they would not be negligent. Also, you would have to demonstrate the legal principle of causation. In the UK, the damages are not awarded to punish a defendant for being negligent. Damages are awarded on the basis of injuries suffered in consequence of that negligence. So we have to show on the balance of probabilities you have suffered an additional identifiable injury in consequence of that negligence on which to base an award for damages. And in fact, cases can actually fail on the basis of causation even if a breach of duty is identified. For example, if there's been a delay in diagnosis of cancer, but the tumour would have spread and sadly someone would have had a poor prognosis in any event, then there would be no injury on which to base an award for damages.